The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to give us a call at 414-253-2080. That's 414-253-2080. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We can also serve you completely virtually. Please enjoy the video.
Hi everyone, this is Matt with Learn About Law, and in this video I'm going to discuss Wisconsin divorce. Specifically, we'll talk about the following. Do you need to show cause for divorce in Wisconsin? How long do you have to be separated before divorce in Wisconsin? What are some recent changes to Wisconsin divorce law? And do you need to show cause for divorce in Wisconsin? Wisconsin legislatures have adopted the trend of no-fault divorce. What this means is either spouse may bring a petition for divorce before a Wisconsin court purely on the grounds they believe the marriage has become irretrievably broken. Note, only one spouse needs to harbor this belief and bring a petition to terminate the marriage. The objection of the other spouse cannot unilaterally prevent the divorce proceeding from beginning. How long do you have to be separated before divorce in Wisconsin? Wisconsin requires that the married couple observe a period in which they have the opportunity to cool down before they can file a petition for divorce before a court. This period is set by Wisconsin statute at 120 days of separation. The reasoning behind this rule is the time can potentially serve as a period of contemplation for the couple, allowing the parties to think through their decision to terminate the marriage. This would also theoretically reduce the number of divorce proceedings brought in the heat of passion, to be then later dropped as the spouses consider the gravity of their actions, potentially reducing the stress on Wisconsin courts. After the 120 days of separation has been completed, either spouse has the right to file a petition for divorce. What are some recent changes to Wisconsin divorce law? Divorce law in Wisconsin has seen the biggest changes in the area of child support. Child support is awarded as part of a parenting plan in divorce to provide the parent with primary custody of the child with financial support, making sure both legal parents are contributing to the economic burden of raising the child. In 2018, Wisconsin lawmakers overhauled several aspects of Wisconsin courts that are able to calculate the child support payments. The goal of these overhauls was more equitable division of parental decision-making. Variable costs saw the biggest change. Variable costs can be understood as the reasonable costs incurred outside of basic support, meaning expenses related to childcare, private schooling, or after-school activities, or special needs as a result of a developmental disability. Before the overhaul, variable costs were the responsibility of the party paying child support, but the parent with primary custody had total decision-making authority over how and when they would be incurred. This created an inequitable situation, with the party paying the expense having no say. The 2018 rule rectifies this situation by requiring the parent to define the variable costs during the divorce process, having an agreement with input from both parties in place before the costs would begin to be incurred. The overhaul also saw an update to the way custody is calculated for the purposes of creating a shared placement plan. Under the new system, custody is broken down into 6-hour intervals, with an overnight now qualifying as 2 6-hour intervals that also include a meal being served. The parent with the most overnights in a year is considered the parent with primary custody. In true shared parenting plans, overnights can be split down the middle. The amount of overnights a parent is awarded has an important implication for child support payments, as the parent is generally considered to be incurring the cost of the child rearing while they have custody. As such, significant inequality in the amount of overnights will correspond to higher child support payments in order to compensate the parent for bearing the lion's share of the cost of the child rearing. To check out more on Wisconsin divorce, check out our article linked below, and be sure to leave any questions you have in the comments, and subscribe for more content daily.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.